Have you recently entered a contract where you feel you were coerced or forced into signing it? Or maybe you entered a contract in which the terms weren't exactly what you thought they were? Well, it seems to me that in your contracts, real assent has been compromised. Now, you might be asking yourself, who is this guy and what is real assent? My name is Tyler Millian, and I'm here today to explain what real assent is and how it affects contracts, including the four main elements. Real assent, according to LSD.law, is a person's real agreement or consent to a contract or agreement. In other words, it's a voluntary agreement of all parties to the terms and conditions of a contract. This means that the two parties understand and agree to the same thing, and a meeting of the minds takes place. Under assent, there's also implied assent, which would be where someone signs a contract without really reading all the terms and conditions. And if you're anything like me, I do this all the time when I have to download a new app or a new software update comes out on my phone. And even though you don't read all of them, you still click sign anyways at the bottom because it doesn't really matter that much to you. Well, that would be implied assent. Real assent would be the opposite. When you read everything, you understand everything about the contract, and you make sure that all of it is factual. The first of the four main problems that can compromise real assent is duress, when someone is coerced or forced into signing a contract. This can either be physical or verbal threats that make someone feel as though they don't have any other option. Duress makes the contract unenforceable. An example of duress by threat could go as follows. Say, for example, there's a worker at a company who just designed a great software system and patented it under his name. The company realizes that if he quits and takes his software with him, it could be a threat to the company. So out of fear, they threaten to report him to the police for embezzlement if he does not sign the rights of the patent over to the company. The worker, fearing jail time and having to go through the courts to fight a major corporation, decides to sign over the rights of the patent to the company. When the employee takes his case to court, the jury will have to decide whether the company made him feel as though he didn't have any free will in an unlawful way, potentially rendering the contract unenforceable. The next problem that can compromise real assent is undue influence. Undue influence is basically a toned-down version of duress. It still involves one party exerting excessive influence over another party, forcing them into the contract. And you're probably thinking to yourself, that sounds the exact same as duress. But in duress, the parties don't need to have a relationship before, and there needs to be a force. Whereas in undue influence, there needs to be a prior relationship, making one party weaker than the other, while there's no actual force involved. An example of undue influence could go as follows. An elderly man is meeting with his trusted advisor about what to do with his company now that he's growing older. The financial advisor advises the old man to sell his company to the financial advisor's friend for an unreasonably low price. But trusting his financial advisor, the elderly man goes through with the sale. If brought to court, the contract can be voided if undue influence has been recognized by the judge. The third problem that can compromise real assent is misrepresentation. This is where one party makes a false statement that the other party believes to be true and enters the contract anyways. The different types of misrepresentation includes fraudulent, negligent, and innocent misrepresentation. Fraudulent misrepresentation includes one party making a false statement to convince the other party to enter into a contract. This is the most serious type of misrepresentation and often leads to damages that are extremely high. Negligent misrepresentation is when one party makes a false statement out of negligence. This is usually due to lack of due diligence or lack of care. And when brought to court, the other party has to prove that the negligent party failed to exercise reasonable care in providing accurate information. And lastly, innocent misrepresentation is when a false statement is made by a party without any knowledge of it being false. If brought to court, this typically won't lead to damages, but it can still cause the contract to be voidable. The last problem that can cause real assent to be compromised is mistakes. Now, we all make mistakes, but in contract law, mistakes can be detrimental to a business. There's unilateral mistakes when one party makes a mistake, which will hold the contract to be valid. And there's also mutual mistakes when both parties are wrong about the subject of the contract. For example, let's say I offer Sean $60,000 for his car. Sean agrees and readies his 2008 Camry with 130,000 miles on it, thinking he got a killer deal. But I go home thinking I bought his brand new 2024 BMW. This is an example of a mutual mistake. A mistake must adhere to three crucial pieces to be considered a mistake in contract law. 1. The mistake must relate to a basic assumption on which the contract was made. 2. The mistake must have a material effect on the exchange of performances. And 3. The party seeking relief does not bear the risk of mistake. A quick recap on what we did today. We talked about real assent and implied assent and the difference between the two. We talked about duress and undue influence and the difference between those two because they're very similar. And we also talked about misrepresentation, including fraudulent, negligent, and innocent. And finally, we touched on mistakes and how all of those elements can cause real assent to be compromised. I wish you guys all luck in your studies and thank you for listening.